detention in more legal acts than in previous ones, and also connected with border procedures. Border procedures were not really covered in that session, but later on. We will have a situation where more persons have to stay in border areas or in special centers, which are used for these types of procedures, obligatory border procedures, and combined with obligatory accelerated procedures. We also have the situation that it's not really clear if they are detained, perhaps only deprived of the freedom of movement, or as NGOs call it quite often, we will hear the position of NGOs as well, is a kind of de facto detention. Then we will have the online presentation on a topic which has been raised quite often today already, return decisions and return of persons. The fourth presentation will focus on another topic which has been raised quite often today, exceptional circumstances and derogations, force majeure, crisis, and instrumentalization. And the last presentation, the final presentation, will be done by, as I said, also a practitioner. She also knows the position of non-governmental organizations in detail. So I think the panel comprises quite an interesting composition of different aspects. And as I have to ask the panelists for comply with the time limit, I have to stop here and introduce the first speaker, well known among, I think, nearly all of us. Lyra Yakovlevichiene is Lithuanian, well-known expert in the area. She is professor at the Mykolas Romeris University in Vilnius, and she is also dean of the law school. She is a member of the Odysseus Network, and she works in the area for quite a long time. So, Lyra, the floor is yours.
Good afternoon. It's really a pleasure to contribute again to our annual conference of Odysseus. And the topic that I will start dwelling on is at least to say by one word is controversial. So let me start from this illusion diagram or ambanigram, how it's called, so you can read it whichever way, and I think that's pretty much what illustrates what I'm going to talk about. Is screening going to be simple? Is it going to be complex? Is it going to be good? Is it going to be a bad? Just to remind ourselves, the screening is going to take place not only at the borders, it can also take place in other parts of the territory, and it will basically involve checking verification of, according to various parameters, health issues, security issues. It will engage registration of biometric data, identification, and then it will be a basis to channel persons to one of the two procedures, either return or asylum procedure. Now, what is good if we compare, let's say, the previous version of the screening regulation and the final version of the screening regulation, already many issues that were coming up, that were commented by NGOs, by academia as problematic ones, they have been deleted or they have been amended. So I think this is a positive development. Now, whether it completely eliminated all the risks, that's a big question that I'm going to talk about. And I will start from three issues where it could be problematic and where a number of questions arise. And today, of course, not all questions can be responded. So firstly, I'm claiming that this envisaged process of screening is blurring actually the distinction between asylum seekers as protection seekers, persons who need to be protected, and other third country nationals who come in irregular manner to the European Union. Secondly, the screening process is not separate, is not a single procedure in a sense of self-standing procedure, but indeed it will impact how persons undergoing this procedure will be treated in the other procedures. And that could also impact the issues related to standards of treatment, proliferation of detention, proliferation of other restricted practices. And the third small point that I would like to, it's not small in terms of scope, but to highlight is the situation of vulnerable persons. And I claim that in the final version of the regulation is still not, the situation of vulnerable persons is still not taken fully into account. So firstly, to start from the fact that actually the screening regulation eliminates this very fine line that existed for many, many years since the adoption of the 1951 Geneva Convention. It's a known fact that asylum seekers need to come sometimes in irregular manner, and their protection needs, they override the, let's say, entry requirements. This is a known fact. But now if we compare the previous version of the regulation and the final version of the regulation, you might have noted a very interesting thing, that actually it's such a minor thing, but we are talking about the objective of the regulation. So initially, the objective of the regulation was to speed up the processes, to make sure that people don't get stuck, that everything is working effectively, that we identify people on time, whether with vulnerabilities or other aspects, and everything goes very, very smoothly. Now, if you look in the final version of the regulation, you see a complete shift, and I think this shift also is one of the very concrete outcomes of this blurring line or elimination of the line between asylum seekers and other migrants or irregular migrants. So the purpose of the regulation now is to strengthen the border control and to make sure that people get controlled, that states get this confidence that was already mentioned by other speakers today, that everything is in their hands and people don't just move where they want. Now, this of course, this is not, let's say, a violation of international law or major concern as such, as long as persons who are protection seekers, as long as they are given access to the asylum procedure. But we have seen both at the legislative level, but also at the practical level, some implications. For example, even in the migration instruments, border control instruments like the Schengen border codes, asylum seekers or persons who need to be protected under international obligations of member states, they've been, let's say, exempted from those entry requirements that are applicable to any other foreigners. So the screening regulation, in effect, legally deprives the asylum seekers from this privilege for the purpose of screening. Then secondly, we have seen a number of practices that have been also mentioned today in the morning session with the pushbacks and other practices at the border, where we see that sometimes the border guards, they do not really differentiate whether we speak about asylum seekers, whether we speak about just irregular migrants. So even in the EU instruments, what we see now, we have one term, all irregular migrants category. So this may have the implications to promote further stereotypes, let's say, in practice, that these people have to be treated in the same way. There should be no exceptions for those who seek asylum. And we see the, let's say, what is happening now with some of the member states. Again, I will not repeat, it was mentioned in the morning. So that could lead to more restrictive practices. It could lead to really more problems on the ground. The second point that I would like to make is, on one hand, it's good that screening is not really a self-standing procedure. So there is no decision at the end. There is no appeal at the end. It is part of other procedures. But what we see from the regulation, that it will impact, and both in practice but also legally, on the other procedures that will be ongoing. And let me start just from practical implication, that even though screening is supposed to be finished within 7 days at the borders, within territory, it's some different time limits, but 7 days. So it doesn't look really problematic. It doesn't look in some way bad. But then if we combine it with the fact that immediately following the screening, there could be other procedures like border procedures, and these border procedures may continue for 12 or more weeks based on the information obtained during screening. Of course, there is a question whether the authorities will go more into details, whether they will collect more information, or whether they will just rely on the information collected. But the thing is that we could have, again, overcrowding of people at the borders. And this is something that we all have seen in the hotspots in some of the member states. We have seen this has been condemned by the CHR. The last case was in 1 year ago. And also European Union Court of Justice pronouncing that, namely, such practices of accumulating people at the borders with very deteriorating standards of reception, this is constituting serious flaws in the reception systems. Despite the fact there is a potential for the screening to contribute to this type of accumulation and this type of procedures. Now, how this could be done? Firstly, what is good is that screening will not result, or will not likely result, in automatic rejection at the borders. So at least this is what has been eliminated. Previously, it was possible in the draft regulation, but in the final regulation, this has been eliminated. So the risk that people will be rejected during screening and will have no right of appeal is really, there is always a risk, but I think it's quite low. So this is a good development since the last draft. But there will be other implications. For instance, considering that the border procedure, there are some examples. For instance, the border procedure could be initiated based on certain nationality factors or security information, or, for example, information about compliance with obligation to cooperate for the asylum seeker. So that may lead to the situation that screening, which is meant to identify and to verify these aspects like security issues, nationality, cooperation of the applicant, that might, this information then channeled to further authorities, might amount to automatic exclusion of, let's say, low merit cases, just based on nationalities, or information collected during screening could be used to channel applicants to fast-track procedures with, as we know, which are with lower guarantees and substantively affecting the rights of persons. Now, the other possibility or example is what do we mean by the fact that person does not comply with the obligation to cooperate? This is, I hope you agree with me, it is quite subjective. There are some provisions defining that in the regulation, but I think still there is quite a broad discretion for the authorities left here, and quite a number of questions could arise here. Now, as I mentioned, screening is not likely to result in automatic rejection of the claims. So as long as persons are admitted, persons who are seeking asylum are admitted to the asylum procedure, which I'm sure will be dealt in the other session as well, there should be no issues. But let me dwell on one particular point with regard to remedy, because there are two issues in the screening where remedy could be relevant. First is, as I mentioned, that there is no decision on screening, only information that will be passed in the format of a form to other authorities. There is no remedy. But as there is right of appeal against the decisions taken in the border procedure that will be following for some of the applicants after the screening, then it seems that this risk is not that evident. Of course, appeals in the border procedure, we also know that they are with some restrictions, with lack of suspensive effect. So here again, there could be some problematic issues. But let me just also remind and imagine ourselves to have those appeals at the border, how practically it's possible. Now, the regulation speaks a lot, and it cannot be, let's say, analyzed separately, for example, from the reception conditions regulation or from the asylum procedures regulations. But I will not dwell on that, but just to mention that even though there are various rights mentioned in those regulations, like right to information, right to assistance, and so on, there is still a lot of possibilities to derogate from these rights on the basis of security, public order, administrative management reasons, and so on. So this access to appeal cannot be, of course, rendered impossible, but there is a lot discretion left to the national authorities. So even though screening will not result in decision and in appeal, then the procedures that it will contribute might also not necessarily ensure that, for example, low merit cases will have persons with low merit cases will have sufficient possibilities to defend what they want to defend. And also in practice, we have a number of cases and case law in European courts explaining the facts of what do we have at the borders. Now, there is another element about monitoring. With monitoring, I will again not cover that at length, but just to mention that if we look at what exactly the monitoring mechanism could lead to, then there are, I think, quite a number of questions about the immediate impacts of the monitoring as remedying access, let's say, to the asylum procedure. I think still it's limited, although this is a good development that we see in the final regulation. The last but not least, implication of, let's say, impact of screening on the other procedures is also very closely related to certain new notions, which are not new in practice, but new in the European Union law. And this is the fiction of a person being not legally in the country, even though physically the person is on the territory. But my colleague Galina is going to speak about that. But just to also mention that in combination with that, I would see on other serious issues, in particular with regard to detention and other protection issues that will be related very much to screening. The last point that I would like to briefly mention is about vulnerable persons. There are many nice and good provisions included for which we can congratulate the drafters of the regulation or the final approvers of the regulation. But one issue that really bothers me a lot is, on one hand, we have the principle on the best interest of the child in the regulation. On the other hand, children and other vulnerable persons, they will be part of screening, so they're not exempted. So in that respect, if we take into account all of those restrictions, taking into account that most of the people, if not all, will stay in detention or similar to detention situations. Also knowing that reception conditions can be restricted, or they can overall, member states can decide to apply them after the screening. In this context, I see it difficult to reconcile the principle of the best interest of the child and the actual situation that we are going to have at the border. Not talking even about the fact that vulnerability screening is a highly complicated process, as we have seen also from practices of some member states, and it's very difficult to imagine how we're going to have doctors and other specialists located at the border and doing these complicated procedures. So to conclude, as my time is over, I think we should not be part of the illusion that this is going to be a simple process, or that it will be simply a, let's say, peace when other issues in the pact are highly complicated. I'm afraid that the process that may seem or is presented like a simple one, like a good one, it may turn into, I hope not evil, if you read that, but it clearly may turn into very complicated, considering that it is mostly going to happen at the border. So because of location, because of capacities, 30,000 people, this is the capacity that the Commission believes at any given time could be at the borders in the screening procedure, and considering also that there is a lot of potential for litigation. So I'm afraid that will not be very easy procedure, but let's see how it will be in practice. And this is where I have to stop because of time. Thank you.
Thank you very much for these insights into the screening regulation. One of the really most disputed, if I can say this, regulations, often criticized also for data protection issues, but of course much wanted by member states for controlling persons who enter. So this is, of course, was a core intention. The next speaker, Professor Galina Cornelis, will focus on a controversial issue as well, on detention and also on the fiction of non-entry. Much could be said about that fiction. We can discuss it later, and so I'll limit myself to the fact that it's a fiction, and we will see the consequence. Galina, the floor is yours.
Thank you. Made a presentation, a PowerPoint with much too much text. So if it doesn't work, it's not a huge problem, but hopefully it will start now. Otherwise, I have to check where I wanted to start. Yes, so I will be talking about detention and pre-entry procedures. And actually, I was asked by the organizers of the conference to focus on a particular question, which was, I mean, it was a pointer to offer suggestions for discussions. And the question was, is the fiction of non-entry problematic, useless, and harmful? And is there something happening with the, okay, you don't know. It doesn't work. I don't know. I think somebody is making gestures. Okay. I'll do it without We'll see, we'll see. In any case, so the question that I'm going to answer today, hopefully, is this fiction of non-entry problematic, useless, and harmful? And very briefly, my answer is it obscures the scope of EU law. It facilitates practices of de facto detention. It exacerbates problems relating to the implementation gap. And it clears the path for even more problematic practices in the future. And it's up to you with these ingredients to provide an answer, what you think with regard to this question. Now, what I want to do, because I only have 10 minutes, I'll very briefly run you through, don't worry, it's too much text anyway. I mean, yeah, we can try, but yeah. Okay. Let's see.
Thank you, Macintosh, for making our lives better.
Just Yes.
Everybody cross fingers.
It's more for myself because sometimes I really feel bad and I can watch the screen and then. So when we talk about legal regulation, and actually, I mean, the organizers of the conference only give me 10 minutes and I have to talk about 4 instruments. So I thought that was not really fair, but I'll do my best to keep to the time. But we have the screening regulation, we have the asylum borders procedure regulation, we have the return border procedure regulation. Then we have the crisis and force majeure regulation, and we also have the reception conditions directive. And I think we need to read them together to get an answer as to how detention is regulated, or maybe I should say is not regulated. Now, my colleague Lira already talked a little bit about the screening. When you look at the screening regulation, you see that the EU legislator kind of keeps it ambiguous whether there is detention or not. So it says that people should not be authorized to enter the territory of the member state. And it also gives member states the obligation to actually ensure, yeah, just run through it and then yes, and then the next one, and then yes. You see, it's too much text. I'm a little bit embarrassed now. But anyway, so during the screening, persons shall not be authorized, and the member states really are obliged to make sure that these people are kept at the border. Or, and that's quite interesting, the screening regulation also provides the possibility to keep people in other locations. But it's kind of unclear what that means for their freedom of movement. Similar problems we can see in the next slide, where we go to the asylum border procedure, where we see a similar idea of the fiction of, yeah, where is the...
Everything is okay.
Sorry, yeah, now I feel really terrible, but anyways. In the asylum border procedure, which can follow the screening procedure, people are also not authorized to enter the territory. And at least there's a little bit more elaboration on whether this means detention or not, in the sense that the regulation says that when they are kept in detention, it should be in accordance with the reception conditions directive. So that's in contrast to the screening regulation, where it's actually left to national law. Also interesting to see is that the use of the border procedure is linked to a recognition rate. And in certain cases where the recognition rate is under 20%, there's a mandatory use of the border procedure. I'll get back to this at the end of my presentation when I talk about, paving the way for more problematic practices. When you look at the return border procedure, that may be the outcome of a asylum border procedure application being rejected, and then people are still not authorized to enter the territory. And they can again be required to stay at these places where they were already staying. I'm a little bit hesitant to say where they were kept. It's very ambiguous. But, these locations at the proximity or at the border or in other locations, and they can stay there for another 12 weeks, similar to the asylum border procedure. Now, in the return border procedure, in the regulation, there's a little bit more elaboration on whether and how detention should be regulated. And I'm not going into these legal intricacies, but just suffice it to say that, again, it's not really clear. The regulation provides member states with the possibility to detain people. And then they say, if you do it, you have to do it in accordance with the return directive. There are certain grounds that are a little bit different in the context of a return border procedure. It's very technical, but it doesn't say that it is detention. Now, Very briefly, the crisis and force majeure regulation also provides for extensions of the border procedure, again linking it to recognition rates in certain cases, so recognition rates of 50% or lower, and also a temporal extension of these procedures. And again, leaving it, and this becomes a little bit boring maybe now, leaving it ambiguous whether this is detention or not. Now, what is very striking there is that in 2013, the European Commission explicitly put forward that border procedures should be exceptional measures because they usually imply detention. And I mean, this is like common sense. If you want to keep people in a certain place, they are generally confined to that place and they're isolated from the rest of the population. So it's a little bit striking, but what is highly problematic, I mean, this is problematic from a human rights perspective, but it's also problematic from the perspective of the idea that was behind the pact. The pact was supposed to repair implementation gaps. And precisely with regard to the situation of people at external borders, I mean, we've seen numerous reports over the years with regard to de facto detention. And what one member state qualifies as detention, another may not qualify as such, which has huge implications. And now I sound a bit like an EU law nerd, but for the uniformity of EU law. And leave aside the fundamental rights, I'll come back to that, but also just the access to legal protection of the individual will differ per country. And it seems a very conscious choice of the European legislator, because in the screening regulation, it literally leaves it to the national states to design policy, rules on this situation. I mean, that is just not understandable from, you know, the underlying idea of why we wanted to have a new pact. It was precisely implementation. What does this mean for legal protection? Because in the end, I'm more interested in legal protection when I compare it to the uniformity of EU law. In the first place, it's very clear. You can try to create as much ambiguity as you want in the screening regulation, but it falls under the scope of EU law. Hence, the Charter is fully applicable and Article 6 is applicable. So, you know, these national rules, you know, hopefully courts will rule that there is not that much room for national discretion. And hopefully there will be a lot of preliminary questions because we need uniformity. Then another issue that I've talked about a couple of times also in my writings, and I don't have time to really go deeply into it, is that this binary opposition with regard to legal remedies when something is on the one hand detention or freedom of movement, it doesn't make sense with regard to current practices that we are witnessing at the border, where the area is gray, and human rights law recognizes that in the sense that they do acknowledge that the distinction between freedom of movement and restrictions on that on the one hand and detention on the other is not a matter of nature, it's a matter of degree and intensity. At the same time, as soon as something is qualified as detention, a whole range of judicial guarantees kick in that are absent when we talk about restrictions on freedom of movement. And I think very problematic there is it's not just the formal habeas corpus review, but it also concerns the use of force in these places where, you know, the burden of proof is much more on the authorities when you're in detention. It relates to fair trial guarantees. There's a lot more involved than just this formal judicial review. Now, perhaps independent monitoring mechanisms may provide, I mean, I'm really putting my hope on the courts, domestic courts, European courts, but also independent monitoring mechanisms. Because the screening regulation does stipulate that member states have to establish monitoring mechanisms. And it also makes explicit that national human rights institutions should be involved, national contact points, the national ombudsman. And I think there's a possibility that these institutions are a bit more sensitive to the changes that we have seen occurring when it comes to practices, as we can call them, containment. And that was my last point, because I said, so it's problematic because it does pave the way for highly problematic practices. And I'm really aware that this is too much text, but I did want to show it, and hopefully the PowerPoints are circulated later. But we see an increasing tendency to reduce the individual to the group where they come from. So, you know, if you come from a country with a low recognition rate, or if you're, you know, a low success asylum seeker, in lots of countries, this is coupled to some kind of problematic asylum seeker, then, you know, it's very easy to use these practices of containment for states, because, and this is literally what the Minister of Justice in our previous government, so not even the one that is in place now, said to justify a certain kind of center, which was formally not qualified as detention. It was a center where you had so many appointments in one day that you could simply not leave. And if you left, you couldn't get any reception conditions, and it was also questionable if your application for asylum was being processed. And the minister said, well, you know, this is not detention, because, well, they got the detention, of course. This is the well-known issue. But the minister literally said in Parliament, it's really unfortunate that we cannot really lock these people up, because unfortunately, they don't usually commit crimes that are grave enough to lock them up. And so then the minister also made the link to the novel border procedures. I do think the minister misunderstood this, because this border procedure can only be applied at external borders, so you cannot kind of take all the problematic asylum seekers in your country and put them in these centers. But we see, you know, this kind of thinking, it really opens up the way for a very problematic tools to manage people, to regulate and manage mobility. Now, another example of this, lots of news reporting today, is of course the return hubs, where you see a similar, this is maybe not pre-entry, but it's a similar way of externalizing responsibility, using territory, formal responsibility. And I think I need to stop, but I want to, because I see Ulrike watching her watch, but I do want to come back to this question. Is it harmful? Is it useless? Is it problematic? I think, yeah, it's problematic and harmful, but it is useful for states that want to kind of look for the limits of what they legally can do, and they provide from the ambiguity that they thus create. But I think what is highly problematic also from a policy perspective here is that it doesn't address the underlying cases, the causes. It doesn't address the drivers of what they call mixed flows. And I think there's also a responsibility for us as academics to engage also with the people that do not qualify as asylum seekers or refugees, that fall outside of the scope of the Refugee Convention, because they have exactly the same fundamental rights as we all do, and they shouldn't be kept in detention for close to a year at external borders of Europe. And it's very important that we are aware of that, and that we look into the underlying drivers to be able to address this kind of mobility, and also make clear, also as lawyers, because this is something, you know, when newspapers or media call us as lawyers, they always ask, is it allowed? Is it possible? But I think it's also very important to think that law is not just instrumental, and policy is also not just instrumental. It should be underbuilt by clear principles that are contained in better regulation. And so you need to look at underlying drivers to be able to address this. Otherwise, you're never going to be able to solve problems. That's it.
Thank you very much, Galina. You really mentioned all the relevant points about, I say, not precise confinement of persons. The fiction of non-entry, I fully agree that EU law is applicable. I would also add, I did it in my blog on detention, that of course member states have jurisdiction under the European Convention on Human Rights, under the Covenant on Civil and Political Rights and other human rights instruments. So they also have to grant an effective remedy if somebody complains that he or she is deprived of liberty in an unjustified way. So this is really an area I think courts would later on clarify. But today we already heard that we see member states not always following the judgments of the courts, but it will be clarified by courts, definitely. So we turn to the next speaker. It should be our online presentation by Madalena Moraro. Madalena, are you already here? Can you hear us or see us?
Yes.
Or both, hopefully?
Yes, I can see you very well and hear you as well. I also started sharing my slides, but I don't know if this is visible.
Happens. So we wait a while. Wonderful. Can you hear us, Madalena?
Yes, I can hear you. Can you hear me?
Yes, perfect. So,
But you cannot
just...
see my slides, so I'll do it again. Just a
Okay.
few seconds. Oh, it's always tricky when participating online. I have to say that I really regret not being there in presence with you. But of course, I am very grateful to Philippe for the opportunity to participate. So hopefully maybe now you can see my slides. And because the time is running fast and it's useful also to leave room for the discussion. I will go straight to my presentation, and that is I will focus on the seamless link between asylum and return procedures under the Asylum Procedures Regulation. And in particular, I will try to discuss what the seamless link means and also discuss potential legal and operational challenges. Now, the relationship between asylum and return procedures within EU law has always presented challenges, and this is mostly because of the difficulty of striking a fair balance between efficiency of return procedures, but also ensuring the fundamental rights of returnees and asylum seekers. Linking asylum with return procedure as such is nothing new because it existed for over 2 decades under Article 6, Paragraph 6 of the Return Directive. However, the Asylum Procedure Directive will bring important changes, and this particularly to the legal force of the procedural link, but also to the individual rights. We are not, though, in uncharted waters. We do have plenty of jurisprudence from the Court of Justice that clarifies the delimitation and the relationship between the scope of application of asylum procedures and return procedures. And I don't have the time to go through all this, but I just highlighted it on my slides, a few important judgments. Now, under current Article 6, Paragraph 6 of the Return Directive, member states have enjoyed flexibility to combine or separate decisions ending legal stays, such as a rejection of asylum application, with return decisions. By now, the majority of the member states actually apply these combined procedures, but the novelty of Article 37 of the Asylum Procedure Regulation is that it will make mandatory, these combined procedures, in a number of situations, for instance, when asylum rejection are based on inadmissible, unfunded, or implicitly or explicitly withdrawn claims. Now, I come to what the potential challenges could be. A first one is quite conceptual, but it's important because it regards the legal formulation of Article 37, which refers to return as part of the asylum decision, rather than the formulation that we have under current Article 6, paragraph 6, which makes return decisions and asylum rejections separate, although only procedural part of the same act. So make it clearer and connecting to what a previous speaker has mentioned. So if we look at the combined procedure as a sort of asylum and return procedure part of the same coin, which is currently the position under the return directive, under the Article 37 of the Asylum Procedure Regulation, the return decision is part of the same side of the coin. And this actually, I would say, blurs the line of the separate legal basis under the TFEU, but also I think it interferes with asylum responsibilities. Oops, that's too far. And the second challenge regards the automatic linking of asylum and return decisions, given that a rejection of an asylum claim does not always automatically entail a return decision. So if we look at the Court of Justice jurisprudence, the court has clarified that a return decision cannot be issued in the following cases. First, for an unaccompanied minor, if adequate reception conditions in the third country of destination are not available at the moment of taking or adopting a return decision. Secondly, if removal to a third country of destination is indefinitely prevented by the principle of non-refoulement at the moment when we rejected the asylum application. And this occurs, for instance, in cases where international protection status is revoked or withdrawn. So in these cases, the Court of Justice has emphasized that there cannot be any return decision issues. Nevertheless, the member state currently still link automatically. So whenever they issue the rejection of asylum claim, they automatically issue a return decision without looking and assessing the principle of non-refoulement in these two cases. And I will connect it also because the rule of law has been mentioned before, I think, by almost all the speakers. So even though the practice of the member state is this that I highlighted, several Supreme Administrative Court have stricken down this, as this is the case, for instance, of the Austrian Supreme Administrative Court. Nevertheless, we see that the enforcement of these judgments sometimes is lacking, thus raising a rule of law issue. The Asylum Procedure Regulation also establishes a seamless link between an appeal proceeding, meaning that a return decision must be appealed jointly with an asylum rejection in the mandatory cases, with an appeal time ranging between 5 and 10 days. I would say that there are several advantages to this because this combined appeal procedure actually simplifies the current varied procedural and institutional framework, and also simplifies the notification procedure to rejected asylum seekers. Currently, in several member states, there are different courts that are involved for asylum and return proceedings, and the courts that deal with return decisions actually do not have access to the judgments that have been delivered by courts in asylum procedure. So this new combined appeal procedure might actually avoid procedural loopholes, institutional hiccups. There's also the advantage that appeal of the return decision will be guaranteed before a court, which is not the case under Article 13 of the Return Directive. The main challenge, I would say, is that if the appeal time is chosen of, let's say, 5 days, it is quite difficult to prepare a well-thought and thorough appeal against both asylum rejection and return, given that the grounds are separate and should be assessed in detail, thus risking that, for instance, non-removability grounds might be overlooked. The seamless link is also extended to the suspensive effect of appeal. So Article 68 extends this. However, it also provides several exceptions for inadmissible and unfounded claims. So in principle, this should enhance the right to appeal that we currently have under Article 13, which does not guarantee automatic suspensive effect. Nevertheless, the scope of exceptions is quite broad, and this brings me to the challenge that I want to discuss, that the scope of the principle of non-refoulement is wider in return cases compared to asylum. And thus, this should also be reflected when automatically linking suspensive effect for asylum and return. So when we consider the exceptions to the automatic suspensive effect of appeal, we should base our assessment on the principles that the Court of Justice has developed in the cases M and others and AA, where the court has clearly said that the protection of the principle of non-refoulement is absolute, admits no exceptions, even for those individuals that have committed crimes or are a threat to public security. To conclude, just a few reflections on the impact and future considerations for the seamless link. There are efficiency gains because there is a simplification of the appeal procedures. There's also an enhancement of certain rights, such as the right to judicial remedy. However, the main challenge, I would say, refers to monitoring implementation in order to avoid the risk of procedural shortcuts and prioritization of expediencies over the full compliance with the absolute protection of the principle of non-refoulement. For more information and more debates on this topic, but also other topics regarding the implementation of the pact, I would encourage you to follow the website of the Access Projects, because at the University of Bologna, we will have a series of 12 seminars discussing in depth the changes that will be brought by the pact. So thank you once again to Philippe for the wonderful, amazing event, and also to Ulrike for the wonderful chairing.
Thank you very much, Madalena. To say wonderful chairing. I could not introduce you, but finally you said yourself that you are at the University of Bologna, so this has done already, and everybody could see how that you are really an expert in the area of return, and also the new challenges in the seamless link asylum and return decisions and procedures, and possibly returns as well. At least when we see what's the intention that one person should be returned. Thank you very much, and I hope you can hear the other presentations and then come back with when questions are raised or when you want to add your points in the discussion. So the next speaker is has 15 minutes because the topic is quite complex. She is professor at the Süleyman Demirel University in Istanbul, Turkey. Professor Meltem İncelisîger is a long working expert, though her young age, in the area of asylum. And she will talk about crisis, force majeure, controversial subjects, and also instrumentalization in the new pact.
Okay, thank you, Ulrike. Ladies and gentlemen, good afternoon. Today I will discuss a very controversial piece of new legislation, namely the crisis and force majeure regulation. I will look at different aspects of Yes. So I will look at the regulation focusing on its derogation regime. The regulation introduces a framework for responding to situations of crisis and force majeure through derogations, raising important questions about fundamental rights. Now let's discuss and learn the definition of crisis. So according to this regulation, the crisis is firstly an exceptional mass influx situation. So we have the definition of mass influx in the Temporary Protection Directive. This is a more refined and clarified version of mass influx provided in the directive. First, there must be a significant influx of third country nationals or stateless persons entering a member state. Secondly, these arrivals must render, and here is the key, well-prepared asylum, reception, child protection, or return system non-functional. So it is crucial insertion of the parliament that if a member state's national systems, return system, asylum system, or reception system already doesn't work, the crisis situation does not add to that. So first, member states should make their national asylum, reception, return system and child protection systems ready for such exceptional circumstances. But despite this readiness, if the member state's capacity is still rendered non-functional, and this dysfunction has a negative effect on the functioning of the SIAS, then we have an exceptional situation of mass influx and the crisis situation according to new regulation. Additionally, instrumentalization is accepted a form of crisis, and this is defined as instrumentalization of asylum seekers and migrants by third countries or hostile actors to encourage or facilitate the movement of migrants to destabilize the Union or the member states. Finally, the regulation also deals with force majeure situations, which is a concept of international law, and it is defined as unseen events beyond the member states' control to fulfill their obligations arising from EU law. And here, the example given that comes to my mind is pandemic. Today, I will mainly focus on three questions in my very limited time. So first, I will look at what potential human rights violations potentially arise from derogations in crisis and force majeure situations. Second, I will look at to what extent does the derogation regime align with international human rights law, especially the Refugee Convention. And finally, I will try to address the question, will the new measures, the derogation, the solidarity measures provided in this regulation will provide an added value? Will it facilitate member states to actually respond to this exceptional forms of migration situations? So, I mean, Lyra has mentioned, Sabrina Galina has mentioned, it has been discussed before. But there are crucial human rights risks arising from the new derogations of this regulation, especially concerning border procedures. So the crisis regulation allows three main kinds of derogations. The first, it enables member states to delay asylum application registrations for up to 4 weeks. Secondly, it enables member states to change the rules of border procedures and mandatory border procedures. And finally, it introduces flexibility within Dublin, now the AMMR system, such as extensions for take charge requests, take back notifications, and transfers. So I will outline three main concerns, human rights concerns relating to this. And first, the crisis regulation permits member states to extend border procedures for up to 18 weeks. This allows asylum seekers to be confined to border areas, transit zones, and other designated locations by the member states for an extended period. Prolonged confinement in such zones, in border zones, may threaten the right to liberty and security as enshrined in Article 6 of the EU Charter of Fundamental Rights and Article 5 of the ECHR. Moreover, frontline member states, such as Greece and Italy, already face considerable challenges in maintaining humane reception and detention conditions at the borders. Lyra already mentioned border procedures might lead to overcrowding and various challenges. These difficulties will only worsen in times of crisis as resources will be stretched further. Inadequate shelter, medical care, and basic services throughout the border procedures may result in inhumane conditions and contravene Article 3 of the CHR, as well as Articles 1 and 4 of the CFR, which safeguard human dignity and right to humane treatment. Now, consider a crisis scenario. And when we talk about crisis scenario, we should talk about large-scale fluctuations. Remember back in 2022, for instance, when the Ukrainian displacement happened and the rate of arrival, if you remember, you will see how this system will not be able to cope with such tensions and such large-scale fluctuations. Imagine thousands of people coming to the borders of a frontline member state. And the crisis regulation enables member states to keep all those arriving, in the case of instrumentalization, for instance, up to 18 weeks. And if their asylum applications are expeditedly processed and they are returned, they should transition to border procedures, return border procedures. They can be in very long periods of time detained and confined. So imagine that you try to do this in a massive fluctuations where people keep coming, seeking refuge from an acute, it can be a civil war, an armed conflict, and then you're trying to keep all these people in border zone or transit areas in prolonged time. So for me, this is not a way to goodly govern any exceptional circumstances. In such circumstances, especially large-scale fluctuations, maintaining humane conditions, proper reception, and in case of border procedures, detention standards, and ensuring procedural guarantees for vulnerable groups become an overwhelming challenge. Sometimes it becomes impossible. The possibility of extending and expanding the scope of border procedures risks creating an environment of prolonged detention, can violate both international and EU principles concerning humane treatment and right to liberty and security. This is quite, I think, important. Secondly, all these procedures include a component of discrimination. The crisis regulation allows member states to apply border procedures in crisis situations to asylum seekers coming from countries with 50% or lower recognition rate based on the latest available yearly Eurostat data. So it depends on what last year the recognition rate was. Depending how this is applied, this provision could subject the majority, or in the case of instrumentalization, all of those seeking refuge during a crisis to prolonged border procedures with few exceptions. This means in crisis situations, individuals can be treated differently based on their nationality and point of arrival rather than the merits of their asylum claims. And this creates a two-tier asylum system in the European Union, depending on whether the member state faces crisis or not. Third risks and human rights risks concerns instrumentalization of migrants. The crisis regulation introduces the concept of instrumentalization, and in such cases, the crisis regulation allows member states to apply border procedures to all asylum seekers that are instrumentalized. In situations of instrumentalization, member states are granted broad discretion to render rapid decision-making of asylum claims. Expedited decision-making, be it asylum or return procedures, risk of errors, and errors that could lead to horrendous asylum and return decisions, which can, of course, violate the principle of non-refoulement. Depending on the application, of course, there is no automatic suspensive effect for appeals in border procedures, and this heightens the risk of deportation before appeals are fully adjudicated, increasing the likelihood of refoulement as well. This can lead to violations of Article 33 of the Refugee Convention and Article 3 of the ECHR. And so, outlining the generally known and well-known human rights risks, let's now look at alignment with international law. Of course, keeping this to 3-minute examination will make it superficial, but now let us address the question, does the crisis regulations derogation regime align with international human rights law and the Refugee Convention? The crisis regulation stipulates that derogation must be necessary and proportionate and must not undermine the Refugee Convention or other international and EU legal obligations. However, questions remain as to whether these principles will be fully respected in practice. Derogation is, of course, not a concept invented by EU policymakers. It is a concept established in international law. For example, Article 15 of the ECHR permits derogations in times of war or public emergencies. Similarly, Article 9 of the Refugee Convention allows provisional measures during war or exceptional circumstances for national security reasons. However, derogations must always be temporary, proportionate to the crisis at hand. While the crisis regulation emphasizes these principles and refers to these principles more than once, it lacks clear definitions of what constitutes necessity and proportionality in crisis situations. I argue that this ambiguity grants the Council, the Commission, and to a certain extent member states broad discretion to decide when there is a crisis and how derogations should be implemented. This risks excessive derogations, such as prolonged detention or extended border procedures, and these instances can be justified even when the situation does not warrant for such extreme measures. Furthermore, the concept of instrumentalization, as introduced by the crisis regulation, is not a clear-cut, legitimate basis for general derogations under international law. This is also noted by UNHCR in a recent information note. The instrumentalization of migrants should not justify derogations from fundamental and for refugee rights, including the principle of non-refoulement, which should be always respected. Now, some scholars, including myself, argue that mass fluctuations indeed can provide a legitimate reason for states to derogate from certain obligations under the Refugee Convention. I think this is permitted, but what is quite crucial is that core refugee rights, like the principle of non-refoulement, should always be respected. Any derogation must be provisional and time-limited. Now, let's look at whether the crisis regulation provides time-limited response. According to regulation, all derogations must not last longer than 12 months and should only be in place for as long as necessary to manage the crisis. However, remember the recent extension of the Temporary Protection Directive to 4 years. There is a clear time limit of temporary protection in the directive Article 4 of 3 years, and the Council, violating this particular article, decided that temporary protection can be extended to 4 years. Now, who's to say when derogations will be implemented, it will not continue more than 12 months? And this is a crucial issue. So my question about the implementation of this provision is, will the time limits on derogations in the crisis regulation be respected, or will we see a similar extension as with the TPD? Without strict oversight, there's a real danger that temporary derogations may become permanent tools. And this leads me to my final point. Is it all bad? Now, so far, I have mentioned the human rights risks that I detected, which can arise from the implementation of this derogation regime. But there are a few positive elements, depending on the application, that crisis regulation might help for frontline member states. And these elements are, first, solidarity measures. We have talked about in the morning session about AMMR. Solidarity measures provided under the crisis regulation are included and incorporated to the AMMR system. And when we look at, for member states experience a crisis or a force majeure situation, other member states can help through solidarity measures such as relocation, financial contributions, but also very creative third country solutions. So depending on how these solution measures are implemented, and also the regulation foresees, and this was also addition of the Parliament, it didn't exist in the Commission's initial proposal, there is possibility to apply expedited procedures for well-founded claims. So when there's a mass fluctuation or a case of instrumentalization, if the Commission proposes, member states can decide to implement expedited procedures, which then excludes interviews and can give international protection status to those arriving to the border. But this is only a Commission's recommendation. There is no guarantee that member states will follow such recommendation. But nevertheless, inclusion of such a possibility in the regulation, I think, is one of the positive few elements of the crisis regulation. And when we look at also Donald Tusk's declaration, recent declaration that Poland will partially suspend the right to asylum for irregular migrants at the Belarusian border, this showed us that compared to today's various interpretations of what is proportionate and necessary in interpretation of the member states, the crisis regulation can indeed, by introducing certain limitations to the derogations, can provide an added value. This is only in view of the case of today, where member states feel free to introduce any derogation measures by giving reasoning of MS influx or exceptional migration circumstances. So, as to conclude, the impact of the crisis regulation will ultimately depend on how its provisions are implemented in practice. While the regulations offer mechanisms such as derogations, solidarity measures, and expedited procedures, the success of these measures will depend on the commitment of member states and the oversight provided by the Commission and the Council. If the crisis regulation is applied in conjunction together with solidarity measures and expedited recognition procedures, or alongside with the Temporary Protection Directive, it can provide valuable support to member states facing mass influx situations. However, if these mechanisms are not implemented effectively, the regulation risks delaying and deterring access to protection for those seeking refuge. It is crucial to ensure that temporary measures introduced by the crisis regulation do not become permanent fixtures of the EU asylum system. They remain exceptional. Strong safeguards, clearer definitions of necessity and proportionality, and robust oversight are essential to provide and prevent future human rights violations and uphold the rule of law in times of crisis. Thank you.
Thank you very much for the balanced analysis of the complex instruments, and you also found some positive elements, which I think is remarkable. We have one more presentation. We started 10 minutes later, so we're a bit late, but I hope we will have enough time for discussion. Catherine Wohlert, the director of the European Council on Refugees and Exiles, will do a legal analysis, but also refer to NGOs' positions.
Great, thank you very much. And anybody waiting for a conflict now, I think will be disappointed, because I largely agree with the 4 excellent presentations that we've heard. What I thought I would do is actually make comments on the presentations rather than opening up new debates, and perhaps to lead us into discussion. So I've got 4 points that refer in turn to the different comments that we've already heard. Starting with the screening regulation. So the 3 elements highlighted by Lyra, I think, are extremely insightful. And what came across very strongly is also the sense of uncertainty about what will be the impact in the end of what is, despite being one of the simpler of the new regulations, there are still a number of uncertainties. For us, I think it's interesting to look at the factors that might influence what is the impact in the end and shape those 3 points that Lyra highlighted. One of those is the question of who actually does the screening. And this is open in the regulation and is being decided now by the member states in their national implementation plans. From ECRE's perspective, we argued very strongly that it should be the determining authority that carries out the screening. That would involve increased resources for those authorities, but this is such an important part of the process. And as we know, there is no remedy, because there is the pretense that this is not a decision, it's a screening form that is issued at the end. The regulation does say that the information in the form should be drafted in such a way that it will assist in judicial review. And to us, that indicates a certain level of quality, and then comes back to suggesting that the determining authority should have that role. A second factor here is also the ambiguity, certain ambiguity about what happens to those who don't apply for asylum. And there, as Lyra rightly mentioned, the real risk of being issued with a refusal of entry that cannot be challenged has been removed thanks to amendments to the draft. They will be referred to a procedure that should conform with the Return Directive. The interpretation of this has to be that they are referred to a return procedure and issued with a return decision, which in turn will be subject to remedy if necessary. And I think the current debate on the return directive going on even today at Council is also an attempt to remove some of the protections that exist within the return directive. So this question of handling that particular relatively limited caseload of those who don't apply for asylum and who don't then get the referral into an asylum procedure is an important factor. And the final one that I would mention is whether the monitoring mechanism and other accountability mechanisms actually go into the question of the form preparation, and we would say the decision making, but of course we know it's not a decision, rather than just having a general monitoring of what's happening in that situation, because the risks in terms of violations are what we see already happening at borders, that people make an application but this is denied or not seen, or there's a pretense that that hasn't happened. And here, the risk that they're referred to the wrong procedure and there's no challenge. So the monitoring mechanism should be getting into the nitty-gritty of this rather than looking more generally at visible violations, for instance, which is also important. In terms of the vulnerability assessment, Lyra's third point, there are questions about when this will actually start. In the screening process, there is an obligation to identify indications of vulnerability, but the vulnerability assessment itself has to take place as early as possible to avoid a situation where vulnerable applicants are ending up in the border procedure. They can then be removed from that procedure, but better to have as an early as possible stage, good assessment of vulnerability. We can come back to that point afterwards, it's quite complicated. My second point on the fiction of non-entry. Our view is that this fiction exists primarily to expand the use of detention. And there have been some rather distracting discussions about what does it mean, this fiction of non-entry? Do protections apply? Do other legal provisions apply? Yes, all of that is the case. This is not extraterritorialization, which has already been clearly stamped down upon by courts. The trick here, and I'm not sure that we can even call it a legal fiction, this is really to allow to be combined with the additional ground in the RCD, Article 10, that allows for, that creates a ground for the use of detention when people are awaiting authorization to enter. So I think Gabrielle's presentation going into all the details of the connection between fiction and detention is absolutely spot on. The question is, which was also touched upon, is the use of detention obligatory? Well, no. Not at all. There is the additional ground for the use of detention should member states choose to use it. RCD Article 10 explains that it is possible to use detention while awaiting the authorization, including in a border procedure. But the ambiguities that you noted, and there are various others in the APR, suggest that it is possible that the border procedure is not taking place in a situation of detention. And from ECRE's perspective, we strongly argue that member states should be choosing not to invoke that ground and not be using detention for the border procedure. So certain member states will want to use detention. They are able to do that now for the border procedure. I think more crucially, certain member states want other member states to use detention. They want those states to be containing people in the border procedure on their territory for fear of the dreaded secondary movement. We're aware that in some of the national implementation plans, certain member states are not planning to use detention when they're mandatorily applying the border procedure, and that other member states are not necessarily happy about that. So I think this is an ongoing discussion. My third point on the next presentation, the question of bringing together asylum and return decisions that we heard from Madalena. I would first just add a side note that after amendment, Article 30, what is now Article 37 of the APR is slightly more nuanced. The return decision can be issued afterwards, so long as that is done without undue delay. So it's not much, but we are quite heavily leaning into that small safeguard that member states can still choose to issue the return decision afterwards. The purpose of this, in our understanding, is really to try to limit access to remedies based on human rights challenges, including those based on protection against refoulement. The cases were mentioned by Madalena. We're talking about the group of people who do not qualify for refugee status or subsidiary protection in EU law, but who may qualify for national protection statuses or may, through a human rights challenge, receive other rights to remain on the territory. From our perspective, this is part of an underlying, extremely unwise attempt to limit the use of national protection statuses. The protection rate in 2023 was 53% at first instance. Of the cases that go to appeal, about a third result in a positive protection decision. So most people arriving do have international protection needs, but we also see the important use of national protection statuses. A number of member states and the European Commission are not very enthusiastic about national protection statuses, and bringing together return and asylum decisions is one way to try to limit their use. What is the likely consequence of this? Firstly, more people in irregular situations, more people with a return decision who are very hard to return at a time where the return rate is 20%. Is it really in member states' interest to increase the pool of people with a return decision where there are questions and challenges about returning them? If we look at the reduction of national protection statuses, one of the other impacts is often onward movement. And I think here the case of Italy and the reduction with the Salvini decrees in 2018 on the availability of national protection status is something that has had the impact of people moving on. My fourth and final point, crisis regulation. Extremely interesting and useful presentation from Meltem, and I think a sensible and convincing approach. Also in her recent working paper, which I would recommend on this, and analysing what would actually assist in a crisis. Also drawing on the TPD experience, rapid access to a protection status, often done through status determination on a group basis rather than individually, more solidarity, often via suspension of responsibility rules rather than necessarily adding solidarity mechanisms. I think the challenge here is the political one, that for a number of member states, maybe not many, their interest in this regulation is not about managing a crisis. It's about finding ways in which to avoid the law, ways in which to avoid legal obligations. Their interest is in derogations, the risks of which were very well presented. Jean-Louis spoke this morning, I thought very convincingly, about the idea of generating a crisis. And that is also partly done, the panic factory, to generate a crisis in order to support this clamour for exemptions and reasons and excuses, legal bases even, for avoiding obligations. the fact that there is this demand to revive the instrumentalisation regulation or to bring other measures also indicates Milton's final point that there is actually a certain constraining element in the regulation. And for some member states, that is what they want to reject. What happens after all of this debate and this lobbying to open up and allow more derogation and avoiding the law on the basis of the concocted idea of instrumentalisation, I think the outcome of that would be determined by political decisions from the Commission. And at the moment, there's something of a hiatus because the new commissioners are preparing for their parliament hearings and not in place. And there's a lot of lobbying to open things up. So will the Commission insist on the conditions that were rightly explained for the use of these measures and even to activate one of these special derogatory regimes? Will they? It's a question mark. It's there in the law. And will they continue to tolerate the current non-compliance, which is justified through reference to instrumentalisation, including statutory level non-compliance? And will they open up the instrumentalisation regulation? We hope yes, no, no, but we'll see based on the politics of some of that. Thank you.
Thank you very much on this precise, really adding important comments on the previous presentations, your precise points and conclusions. So I'll now open the discussion. You have to help me if there are any online questions or if we should start here. If you don't have online questions, yeah, somebody?
Good afternoon, my name is Amanda Bisong. Can you hear me?
Yes.
Okay, my name is Amanda Bisong from ECGPM, and I have a question about the screening regulation, but any of the respondents on the panel can respond, can answer the question, including Lira. Looking at the regulation, we see that it provides for checks at the external borders, which Lira discussed extensively, but also checks within the territory of member states. My concern then would be around issues of racism, around issues of xenophobia, and also identifying persons who would be screened. So how do you create a distinction between people who have reason to be within the territory and people who are presumably within a category of people that need to be screened? So for example, as a Black European, then what happens to you? Do you get stopped every time at every possible check? And while I understand that the regulation also includes measures to bring in monitoring, especially bringing in the different national human rights councils, how will this be implemented in practice to avoid human rights infringements? That's my question. And are there any caveats in the regulation that consider this aspect of the application?
Are there other questions elsewhere, please?
I'm a repeat questioner here. And I have one question for Lira and one for Galina Lavalina. And so Lira, as I understand it, in the board of return procedure, there will be 3 decisions in one decision. So there'll be a decision on whether or not this is a refugee and a refugee convention. There'll be a decision on whether or not the person is an Article 15B or C person in identification, and there will be a return decision in respect of which non-refoulement will be essential. And one of the things which came up in a discussion with a judicial authority was when the authority is presented with those 3 different decisions and the non-suspensive effect, and the CIC is asked to provide suspensive effect or determine the decision, how are they supposed to address all of these different questions which engage completely different areas of law? And my second question to Galina and Magdalena, and it's about Article 68, which you both mentioned. And in there, you've mentioned the horrible 5-day time limit suspensive effective appeal rate. But you haven't developed, and I'd be very curious to know what you have to say about in those provisions, twice, there are directions to the tribunal to make decisions ex officio, which presumably means without an individual decision, that they themselves go forward and look at a situation and then make some kind of decision. But I'm not quite sure what's meant by this ex officio, and I wonder what you make of it.
Are there any other questions here in the, yes, please?
I'm sorry, can we please have the first question from online, since we have this priority for online?
Of course.
I'm sorry.
Of course.
Hear me?
Yes,
Just
I
to
hear you.
verify before. Yeah, okay, thank you. So again, Olena Sikvo, Fundamental Rights Monitor from Frontex. So my question relates to the identification of vulnerabilities and specifically to the presentation by Lira. So you said that the main implication of the screening regulation on vulnerable persons would be the fact they will be also part of the screening procedure, which eventually may lead to let's say, border procedure with reduced safeguards. But my question is it really problematic? Because what would be the alternative solution? Because indeed, the screening provides also for a framework for the identification of vulnerabilities. How else these vulnerabilities will be identified? I mean, there's always, of course, a question of how efficiently this will be implemented and how effectively the let's say, vulnerabilities will be identified. But my question, why do you see this as a concern? To be, let's say, to include identification of vulnerability as a part of screening process. So this is my question. I hope I was clear enough. Thank you.
Thank you. And we would continue here, and then I think we should answer the first round of questions and see if there are any others. Please.
The screening procedures and the assessment procedures. I understand right now that the Commission may encourage member states to implement movement restrictions. This will happen based on the general presumption of funding, and the legal basis Article 9, Paragraph 1 RCD, which becomes clearly as I understand the sub-provision when we refer to all the procedures and screening procedures. However, even in such cases where the aim is to prevent absconding, even in these cases, it's impossible to have 0% absconding. So what happens if a person finally absconds and is apprehended later, maybe in the territory of the same member state or another member state? Will this person be considered to have a entry into the territory? Or, I mean, is there an end to this non-interdiction, or it follows the applicant forever when you get that once to abscond finally? And
Yeah, you can answer the questions. I don't think it's necessary to say who is first. I mean, you were all addressed by questions, so.
And maybe I will start, as there are quite a number of questions related to screening. I would like to be able to respond to all of them. but I think some issues are still not clear. But let me dwell on firstly the issue of screening in inland. Just because of time, I have not been covering this as one of the problematic issues. Indeed, there are comments that this might, let's say, proliferate the practices related to racial profiling of persons in the territories. So people will be stopped just because the way how they look. I actually myself witnessed such a situation in one of the Greek islands in the street, just unexpectedly, not addressed to me, but to people who looked slightly differently. Now, here, I think there are two issues. One issue is indeed the very practical issue of evidences. Now, the screening should apply to those who entered illegally, but were not irregularly, but were not subject to screening. The question is, how do you prove that you entered regularly, let's say, in particular if the person has entered long time ago? So I think that's one of the practical implications. Second is that considering that there are already practices, not very good practices by the police authorities in the territories of states or some states, and we had, I think, the first of such type decision by the European Court of Human Rights, and in the case of Wabaila versus Switzerland, actually from this year. So that also shows very clearly that we do have practices that have been condemned and where people are, let's say, profiled based on appearance. And indeed, we have not discussed today about use of various technologies in border procedures and other procedures, but indeed they're being used, and with continued and increased use of technologies, it will be even easier, let's say, to profile people, and there might be even more concerns related to that. So that would be my my response to the first question concerning the potential for xenophobia, racism, and problems of screening inland. Then on the monitoring, how to implement and practice the monitoring of screening inland, I think it would be very difficult for me to respond, because even monitoring at the borders, there have been already certain monitorings going on right now. We see the added value of monitoring. We also see the limitations, where in order to get access, let's say, to difficult situations, the monitors are sacrificing what they are putting in their reports. So there are a number of issues related to that. So it's even difficult to see now how the monitoring will work in practice at the borders. What is clear that there could be various checks and ad hoc and not ad hoc regular checks. I think from the regulation, I would imply that they would not be part of the decision making, but rather as an independent observers. So I would not see that connection to the decision making by monitors. But as I mentioned in my intervention in the beginning, that for the time being, it's not really clear what will be the immediate impact of monitoring, because when they report and where, let's say, they will facilitate or will bring to the authorities the need to initiate certain cases or so on, that's clear. But whether they will have, let's say, the immediate effect or immediate actions that they will be able to take if they see that something is completely wrong, it's still not, it's still to be seen in practice. On the question from Frontex, I think, person on vulnerability, why I see it as a problem. Indeed, I don't see identification of vulnerability as a problem as such. My point was that screening does not really exempt vulnerable persons, and considering that majority of people will likely to be detained during screening, I see it difficult to combine with the, let's say, the best interest of the child or the good, the needs of vulnerable people that need to be addressed. Again, how this will work in reality, it's difficult to say because the regulation sort of refers to preliminary vulnerability identification, but the question is what happens then? Now, if it is in the border procedure, then they should be excluded from the border procedure. But until then, they could be detained, all the restrictions, let's say restrictions on the reception conditions and all the other outcomes that are possible, restrictions of standards that are possible during the screening will be implemented. So my point was more there. And also, secondly, if we do proper vulnerability assessment, then again, the screening regulation says very nicely about all the capacities and what you were mentioning about what kind of people will have to do screening. It's very nicely done in the regulation in Article 8, saying that this has to be competent people, that they have to be trained, that there should be medical staff. But in reality, we remember, for example, how much or how many medical professionals were in even inland. So this was a big issue. So I'm just wondering how to make sure that this procedure would be carried out at the border with those professionals who are usually lacking. So that was mainly the point, but not the fact that it's not good to have identification of vulnerability. Actually, it has to come as soon as possible once the person is identified.
Wanted to.
I'll be very brief. Article 68 and the lack of suspensive effective appeals. In some cases, I would say this is plainly in violation of the right to an effective remedy in Article 13 of the ECHR and also the Charter. So it should be litigated. And what is problematic there, of course, is because the provision does make it possible for a court to actually provide suspensive effect. But the problem precisely with keeping such large groups at the border is access and having them legally represented. So to give a court this possibility to give the suspensive effect when it's requested is simply not effective. And I would say there are good arguments to be made on the basis of Article 47 of the Charter to say that this is not effective. Very interesting question with regard to absconding. I would say a return directive is applicable when you abscond from border detention and you're later found in the territory of another state. That is not a reason to exclude the return directive. So you're clearly entered and the fiction of non-entry doesn't apply. I would like to have a discussion about this whole idea of a fiction of non-entry. I think most of the law in that sense operates from fictional ideas, but that we keep for another day. Thank you.
Yes, could I come in on that? I think there's a lot of ambiguity on how far the fiction stretches, and it's partly also because it's not about entry, it's about authorization. So clearly people have entered, but they haven't been authorized, and that allows this then to be engaged. So one interpretation would be that the fiction continues so long as there's no authorization. But is that stretching it just too far? I think it is a wider discussion to be had. Yes. I mean, we would argue the same as well, but I would. It's also something where I would expect to see an attempt to stretch it. I mean, also because the whole concept of it is also quite problematic. In terms of the situation at the border and the number of challenges that an applicant will have to engage in at one time, I think this is really one of the points at which violations are most likely to be appealing the asylum decision, the return decision, and requesting the right to remain at the same point. With what access to lawyers who are going to be there to provide this, I think is a challenge. On the point mentioned about effective remedy, to us, this rests on a very disingenuous interpretation of Gurnandi, and it's an area that looks very likely to be subject to challenge. I mean, in the sense that the claim is that you're removing not removing the right to remain, not suspending the removing automatic suspensive effect. So I think that that will come up. Finally, on vulnerability, I would agree with Lyra that this is a bit more complicated because without the automatic exemption of vulnerable applicants from certain procedures, the way that vulnerability is now formulated, it sits in at least 3 different steps. There's the general obligation on all authorities involved to identify indications of vulnerability, which is something positive. So border guards, everybody present should be and is obliged to note indications. After that, it goes into full vulnerability assessment, but the vulnerability assessment has 2 elements. It's partly about identification or assessment of special reception and special procedural needs, because the language is not about vulnerability, it's about applicants with special reception needs or in need of special procedural guarantees. So firstly, identifying those needs, and then secondly, assessing whether or not those needs can be accommodated in certain procedures, in certain settings, or if other measures have to be introduced in order that the applicant can then avail themselves of their rights and meet their obligations. So yes, as early as possible, but is it realistic to have a thorough vulnerability assessment at the screening level, given the timelines? So that is our concern. And it has to be the determining authority doing this. So we're putting everything on the determining authority, but compared to the alternatives. And that means they need to be heavily present at the border, as well as the specialists that you refer to. So ultimately, our argument here is that it is easier to have a general practice that is based on generally using the presumption that special procedures are not suitable for these applicants, and having a practice of exemption, even though there isn't automatic exemption. Just a small final point, in terms of not having the right to remain, one of the other slightly legally dubious things that we've recommended is that authorities allow applicants to remain even if they don't have a right, just because the consequences of removing that right, as everybody has discussed, and therefore ending automatic suspensive effect, are legally and practically problematic. But that's just NGO constructions, maybe.
So I saw Madalena agreeing to the statements, but you might have special answers or additional comments. Madalena?
Yes, thank you, Enrique. I have to apologize that the volume of the question made by the in-person public was very low, so I could just guess some keywords. I would first like to address the remarks of Catherine. I think very good points, and I agree we should rely on the interpretation of Article 37 with the nuanced wording, because there's an option of having asylum rejection decisions and return in separate acts. But then if we look at how the policy proposals for this implementation, if we look in soft law instruments, from the action plans on the implementation of the return directive ranging from 2017 up to the 2023 recommendation of the Commission, we see the focus, the prioritization is in having a combined decision. So the purpose of my presentation was to highlight that we're not sailing in uncharted waters. It's true we have new instruments, but we have prolific jurisprudence and principles that have not been thoroughly reflected in the legislation, also because you cannot really, up to a certain point, codify everything that the Court of Justice is saying, also because it's evolutive. So what we need to do as practitioners, we always need to ensure that we interpret these provisions in light of the principles developed by the Court of Justice. And this leads me to the point of the ex officio assessment of the suspensive effect of appeal. I definitely agree. So the formulation is in the asylum procedure regulation is as an option, although we know in the Gandhi formulation that this is very much an obligation in regard to return decisions. And I definitely agree with what Galina mentioned. Then from the public, I could only hear something mentioned by Elspeth, which was a 3-in-1. So I guess that when she referred to this phrase 3-in-1, she referred to decisions in screening, asylum, and return at the border. And I agree. I think it will be very difficult because although these are very distinct and separate phases, they are part of the same decision making. And I think without not necessarily only advocate monitoring, but independent, and I would like to underline this, the independent monitoring of how this will be handled, it will be quite difficult to ensure respect of the principle of non-refoulement. And last point with national protection status. Catherine mentioned that, of course, when assessing the principle of non-refoulement in regard to return, we should also look at the national protection statuses. I think there has been quite good jurisprudence developed in Italy by certain courts. So we all know the XNX humanitarian visa case of the Court of Justice, not a welcoming case as regards the right to asylum and application of the EU Charter. But then if we look at jurisprudence from Italian courts, we've seen that they've not agreed with this interpretation, and actually they did grant and oblige the conferrer of humanitarian visas on the basis of the constitutional right to asylum. Of course, there's, and it has been mentioned by many of the presenters today, there's a clash between the government approach and then the judgments delivered by courts, because although we have several judgments pro human rights and proper implementation of EU law from courts, these are not always implemented in practice, and it spans from east to west. So I would say that we are also facing a problem of proper implementation of court's judgments. So I'll restrain to this, but Ulrike, if there was a particular question that was addressed to me and I haven't replied, please feel free to resume it, because I couldn't hear the questions in the public.
I think we should close the session now. I could not remember all the points from that question as well, but if we did not answer the question, we could come back in a later session. Everything overlaps slightly, and I don't think any question will be left open except those we cannot solve, and these are many, so we can only tell our opinion on that. So we have 15 minutes, Philip. I look at you, 15 minutes, 20 minutes, generous 20 minutes coffee break, and then the final presentation.